Your deposition is a tool that the other side will use to find out what you know, to commit you to a position, and to search for a weakness in your company's case. It's a formal legal procedure in which the lawyer for the other side will ask you questions in what looks like an informal atmosphere. And this very informality can be quite disarming. The setting resembles an ordinary business meeting. Depositions usually take place in a conference room with you, your lawyer, the opposing counsel, and maybe lawyers for other parties seated around the conference table. But there are important differences. You are under oath, and a court reporter takes down every answer you give. And the things you say will have a direct bearing on the outcome of the case. What you say at this deposition may determine whether or not the case is settled, and if it is, whether or not your company will be happy with the result. Of course, if the case is not settled, it will go to trial, and you may be called as a witness. Before you get on the witness stand, the answers you gave at your deposition, maybe years before, will be studied by the opposing lawyer. If your answers were dishonest, or if they were simply foolish, they will be used against you at the trial. There's one other important difference. You are the only one on unfamiliar turf. Lawyers have special training and experience in this procedure, and you do not, at least not yet. To help you prepare, we're going to take you to several depositions so you can see the kinds of situations you're likely to encounter. We'll show you the mistakes most people make, and then we'll give you the knowledge that will help you to avoid them. We're about to see the deposition of the chief executive officer of a major industrial company. His firm has tried to buy up the stock of a smaller outfit called Corrosive Chemicals. The lawsuit occurred because Corrosive didn't want to be bought out, and they went to federal court to stop it, claiming that our witness and his company were up to no good. Our witness is a confident man who has always gotten his own way before. Let's watch what happens to him now when he faces an attorney whose job it is to handle men like him.
About 10 days ago.
Mr. Jones, why did your company make this tender offer for Corrosive Chemicals Corporation?
Well, I'd gotten this call from an investment banker I've known for some years. He wanted to know if I had any interest in acquiring Corrosive Chemicals.
Investment banker?
Yeah, Dick Johnson.
Dick Johnson.
So I said, sure, you know, let me see some information. And so he sent me up a memo later on in the day.
A memo?
Yes. So I called up Jerry Bookbinder. Oh, he's my VP of Finance.
Right.
And I asked Jerry to look over the memo and get back to me later on that afternoon.
And did he?
Oh, yes. He had his staff put together a complete financial analysis. And it looked very promising.
It did?
Yeah. So the next day, I called a meeting of my executive committee, and they all thought the reports looked great.
Ah, did they?
Yes, yeah. Oh, except for the head of the audit committee. He said that he wanted to get some legal input, so we all decided to meet later in the day. Well, when my lawyer looked at those reports, he said, boy, have you got a problem. What's the matter? What did I say?
What did he say? He said too much. He made a very common mistake. He volunteered. He was really asked only one specific question: why? But instead of answering just that question, he began to tell a story. Let's rerun this scene and see exactly what it was our witness volunteered.
Mr. Jones, why did your company make this tender offer for Corrosive Chemicals Corporation?
Well, I'd gotten this call from an investment banker I've known for some years. He wanted to know if I had any interest in acquiring Corrosive Chemicals.
Investment banker?
Yeah, Dick Johnson. So I said, sure, you know, let me see some information. And so he sent me up a memo later on in the day. So I called up Jerry Bookbinder. Oh, he's my VP of Finance.
Right.
And I asked Jerry to look over the memo and get back to me later on that afternoon. He had his staff put together a complete financial analysis. And it looked very promising. So the next day, I called a meeting of my executive committee, and they all thought the reports looked great. Except for the head of the audit committee. He said that he wanted to get some legal input. When my lawyer looked at those reports, he said, boy, have you got a problem.
There were at least 9 points that our witness volunteered. Now, let's watch what the opposing counsel will do with that information.
Okay, well, thank you, Mr. Jones. I'd like to go over some of these matters with you in a little more detail. Let's start from the top. This investment banker, Dick Johnson, who does he work for?
Dick, he's a partner in the firm of
Now, that analysis that your Mr. Bookbinder's staff prepared, where is that report now?
we destroyed the report.
I see. Exactly when did you destroy that? I believe you mentioned something about the head of the audit committee. What's his name?
Oh, well, that's Bill Morgan. He's been with the firm for 15 years. He came from,
Now, you said your lawyer told you that he felt you had some problems. Exactly what problems did he tell you
I
about?
object on the grounds of attorney-client privilege, and I direct the witness not to answer.
John, your client volunteered that information, and I'm going to apply to the judge for an order to compel your client to tell the rest of the story.
Do whatever you want to do.
I will.
That's why you never volunteer. Once you introduce the subject, you can be sure the other side will question you about it. And at that point, you will be required to discuss it in detail. As you saw, this even applies to such privileged information as discussions that took place between you and your lawyer. You are obliged to answer each question fairly and honestly, but you don't have to tell anyone your whole life story. You should answer only the question you're asked. Keep your answer short and then stop. If the opposing lawyer wants more information, it's his job to ask you another question. Let's see how a more careful witness could have handled this situation.
Mr. Smith, why did your company make this tender offer for Corrosive Chemicals Corporation?
It was a good investment.
Or what made you think that it was a good investment?
We could make money on it.
So you thought Corrosive was attractive because the stock was selling at a low price?
That's right.
Well, what made you think it was selling at a low price?
The Wall Street Journal.
How's that?
I could tell the price from looking in the back of the Wall Street Journal.
All right. So when you looked in the back of the Wall Street Journal, the price of the stock appeared to you to be low.
That's right.
Low compared to what?
To what it was before.
Exactly what did your lawyers tell you about this deal?
That is privileged, and I direct the witness not to answer.
This witness took it slowly and listened to the questions. He answered only what was asked. He kept his answers short, and he didn't volunteer any information. He also paused before every answer, and this gave him time to think. It also gave his lawyer a chance to make an objection. So, this time around, the other side wasn't able to pry into any privileged areas. Now, what have we learned from this sequence? Number one, listen to the question. Number two, pause before you answer. Number three, keep your answers short. And number four, never volunteer. Now let's see how even a witness who has a little bit of experience can still be led into a trap. A good lawyer will try to put words into your mouth by asking you a tricky question. You've probably heard the classic example. Have you stopped beating your wife yet? No means that you still beat your wife, and yes means that you used to beat her. It's a no-win situation. And you have to watch out for it carefully because it can be very hard to spot. The trickiest questions are usually asked in the friendliest, most conversational style, or they're hidden in a series of perfectly straightforward questions. In this next deposition, our witness heads a department in a big market research company. Her company's client, an orange juice producer, has gone into court to try to get an injunction against a TV ad being run by the competition. They claim this ad is hurting their business because it's misleading. And they are basing this claim on a consumer study of the ad that our witness was hired to perform. The other side is out to discredit that consumer study, as you're about to see.
And when did Golden Ray Orange Juice come to you with this project?
Oh, about 6 weeks ago.
Who did you deal with at Golden Ray?
Oh, lots of people.
Who is your principal liaison?
Oh, that was Jim Gerard, the VP of Marketing.
Had you worked together with this Mr. Gerard before?
Oh, yes.
Before you began this project, did you have any agreements in writing as to what you would do?
Oh, no. It was very informal.
Was there any written budget?
No, no written budget.
Had you had any discussions about what it would cost?
Oh, yes, of course.
What was the assignment that you got from Golden Ray?
To do a good scientific research study, to take the ads and see how the consumers reacted to them.
And you concluded that the ads were misleading?
Oh, yes.
Did you estimate the amount of time required for the various parts of the project?
Oh, yes.
And how many man-hours did you estimate would be required to show that the ads were misleading?
About 400.
Who actually did the work on that?
Our regular interviewing staff.
And how many hours did they actually spend?
About 410.
At some point during that exchange, our witness missed a tricky question, and she gave the other side the ammunition they were seeking. Let's listen again closely to one particular question.
Did you estimate the amount of time required for the various parts of the project?
Yes.
And how many man-hours did you estimate would be required to show that the ads were misleading?
About 400.
By answering that tricky question, the witness implied that the firm had set out all along to show that the ads were misleading. How could she have avoided giving this answer? A witness who listens to the question will hear the trick. And at that point, there are two things that can be done. First, a more careful witness can simply pause before answering each question. By doing so, this witness will give her lawyer time to object.
Did you estimate the amount of time required for the various parts of the project?
Yes.
And how many man-hours did you estimate would be required to show that the ads were misleading?
Well,
Objection to the form of the question. Your question assumes that they set out to show that the ads were misleading.
Okay, I'll rephrase the question.
The second thing a careful witness can do is to ask for a clearer, fairer question.
And how many man-hours did you estimate would be required to show that the ads were misleading?
I don't think I understand your question.
Why not?
We weren't trying to show that the ads were misleading.
Oh.
How can you protect yourself from the tricky question and keep the other side from putting words in your mouth? First, listen, and listen hard to the question. Then, pause before you answer. This will give you time to think and your lawyer time to object. And finally, if you have to, ask for a clearer, fairer question. Asking for another question can be hard to do. After all, when did you ever hear a witness ask Perry Mason to explain a question? The fact is, you're entitled to a question in clear, simple English, without any hidden meanings. And you have the right to interrogate the interrogator to make sure that you get it. Our third deposition will show you how to do just that. We're going to look in on a case where a movie studio and its accountants are being sued by the investors in a film that flopped. The investors claim that the studio paid no attention to how their money was being spent, and did nothing to stop cost overruns. Our witness is the assistant to the president of the movie company, and he's much more concerned about appearing confident than he is about making sure he understands the questions. Whenever you're asked a question that sounds unclear or ambiguous, you should never try to muddle through or pretend you understand it. Even though you might feel foolish, you must ask the other lawyer exactly what he means. Otherwise, you may find yourself, like this witness, involved in a much more serious folly, namely, committing yourself to a position you never meant to take. Watch.
You are aware that there was a meeting of the board of directors of Celestial Cinema on January 15th?
Yes.
Did you participate in the January 15th meeting?
What does he mean by participate? Does he mean, was I there, or did I speak up? I was there, but I didn't say anything. Oh, well.
No.
Before that meeting, did you review the briefing materials that are marked as Exhibit 31?
Well, I did check over those materials, but I didn't really actually review them.
No, I didn't.
At any time, did you see an audit report on the production expenses?
I remember seeing a financial report. That's what tipped us off to the overruns. But I don't think it was an audit report.
No, I didn't.
Every one of those questions could have been answered in at least two different ways, depending on what the lawyer meant by a key word. But instead of asking for an explanation, the witness chose to interpret those key words for himself. Then, he provided answers to the questions he thought he was being asked. He may have saved himself a few awkward moments at his deposition, but we'll see how he bought himself some serious problems later, while being cross-examined at the trial.
Mr. Brandt, when your lawyer questioned you just now on direct examination, you said you were at the January 15th board meeting, that the board discussed a financial report on the production, that they instructed you to get on top of the cost overruns at that time, but that by then the damage had been done.
That's correct.
But at your deposition in this case, were you not asked the following questions, and did you not give the following answers? Page 165. Question. Are you aware that there was a meeting of the Board of Directors of Celestial Cinema on January 15th? Answer, yes. Question. Did you participate in the January 15th meeting? Answer, no. Question. Before that meeting, did you review the briefing materials that were marked Exhibit 31? Answer, no, I didn't. Question. At any time, did you see an audit report on the production expenses? Answer, no, I didn't. Were you not, in fact, asked those questions, Mr. Brandt? And did you not, in fact, give those answers?
Yes, I did, but
Thank you, Mr. Brandt. No further questions, Your Honor.
Mr. Brandt should have exercised his right to interrogate the interrogator at his deposition. He could easily have saved himself the embarrassment you just saw if he had asked for a clearer question before he committed himself to an answer. A different witness, who had been better prepared, would have made sure he understood what was being asked. Let's take a look at what should have happened at that deposition.
You are aware that there was a meeting of the board of directors of Celestial Cinema on January 15.
Yes.
Did you participate in that meeting?
What exactly does he mean by participate? What do you mean by participate?
Did you take part? Did you speak up?
No, I didn't say anything at the meeting.
But you were there.
Oh, yes.
Before that meeting, did you review the briefing materials marked as Exhibit 31?
Review. What does review mean? What do you mean by review?
Did you read them all thoroughly?
No, I didn't read them thoroughly.
Did you look at them at all?
Oh, yes, I did.
Never be afraid to ask. And while we're on the subject, there are a number of things you should ask your own lawyer before the deposition. Be sure to bring to his attention any areas that are troubling you, or which you think could be damaging to you or to your company. If you don't get your lawyer's advice in advance, it will be a lot harder for him to help you. You should also ask your lawyer how he wants to interact with you during the deposition. For example, what does he want you to do if you need his advice in the middle of the questioning? The lesson of this sequence is simple. A careful witness always asks. Ask the other lawyer for a question you can understand while you're at the deposition. And ask your own lawyer to clear up any points that trouble you before the deposition. We've gone over a lot of ground, but there's still a few points left to cover. And we've saved the most important point for last. Always be honest. You'll be under oath at your deposition, and you'll be swearing to the truth of everything you say. You must testify honestly, and you must never try to fill in things that you think might have happened, or add things that you think you ought to say to make your testimony sound better. Never be afraid to say that you don't know, or that you don't remember. If you're asked a question and you don't know the answer, from your own knowledge, you must say, "I don't know." Take our next and final witness. He's the chief engineer for a small manufacturing firm that is suing a European company for stealing its trade secrets. Our witness has to try hard to remember who said what to whom at a meeting held several years ago. Unfortunately, he doesn't know that more witnesses get in trouble for guessing at answers or filling in gaps in their memory than for any other reason.
These trade secrets are worth how much, Mr. Atwood?
About $5 million.
And you say that someone from my client admitted that these trade secrets were the property of your company?
That's right.
And who was it who admitted this?
Mr. Gruber, Bonhoeff's vice president for manufacturing.
Are you quite sure that he said that these so-called secrets belonged to your company?
Oh, yes, quite sure.
Where exactly did Mr. Gruber say this?
At a meeting in my office in Princeton.
And when was this alleged meeting?
You know, it's been almost 3 years, and I just can't remember for sure when that meeting took place. If I say I don't know, she'll make it sound like I just don't know what I'm talking about. Well, it must have been in September, because I remember it was right after the plant closed for vacation. Of course, it must have been in September. It was in September.
Mr. Atwood just guessed about when the meeting took place at his deposition. And now he's going to be cross-examined at trial.
This agreement is worth about $5 million to you and your company, isn't it, Mr. Atwood?
Yes, I guess it is.
And you're positive that Mr. Gruber said that the trade secrets belonged to your company, and not merely that he understood that you felt that way?
Absolutely.
You wouldn't just be filling in your memory a little bit because it's worth $5 million to you.
No, of course not.
And Mr. Gruber allegedly made this admission during a meeting held at your office.
That's right.
And when did you have that meeting with Mr. Gruber?
That was in September.
You are aware, aren't you, that Mr. Gruber is a citizen of Germany and that he cannot travel back and forth to this country without a passport?
Yes.
And that you have to have your passport stamped before you can be admitted to this country, right?
I suppose so.
I show you Exhibit 49, the passport of Mr. Gruber during the period in question. Please, look through the passport for me and confirm that Mr. Gruber did not enter this country in September, and that he was not here in July or August, and that, as a matter of fact, he wasn't here in October or November either. Isn't that right?
Yes.
So, when you said you had a meeting with Mr. Gruber in September, you were filling in to help your company get that $5 million.
I must have just been mistaken, that's all.
And when you say that you're sure that Mr. Gruber admitted that the trade secrets belonged to your company, and not that he knew that you just always felt that way, you aren't just filling in there, too, are you?
Oh, no, no.
Oh, so what you're telling me is that you were filling in about when the meeting happened, but not about what happened at the meeting?
I don't think I can answer that.
No further questions, Your Honor.
That's what can happen when you make things up. If Mr. Atwood had given the honest answer that he simply did not remember when the meeting took place, what you've just seen would never have happened to him. If you don't know something, or you don't remember, say so. Never guess or fill in when you're under oath. If you only testify as to what you know personally, you'll never get tripped up. It might have seemed at the beginning of this program that the opposing counsel had all the odds stacked in his favor. But you've seen that there are several things that you can do to even up those odds. Never volunteer. Answer only the question put to you, and keep your answers short and direct. Watch out for the tricky question. Listen hard, then pause before you answer to give your lawyer time to object. When in doubt, ask. Interrogate the interrogator to get a clearer, fairer question, and ask your own lawyer to clear up anything you don't understand. Beware the foibles of memory. Honesty is always the best policy. Don't ever be afraid to say you don't know or you don't remember. Of all we've shown you, the most important point is this: always pause before you answer. Particularly if you start to feel nervous at your deposition, pausing before you answer will help you to stay calm and in control. You've seen the general kinds of mistakes that most people make, and you've seen how you can avoid them. Once you and your lawyer review the specifics of your case, you should do just fine in your deposition. Good luck.